Welcome back to Courtroom Chronicles, where real justice unfolds one gavel strike at a time. Today's case is a roller coaster of contradictions, excuses, and cold hard facts. The defendant, already on deferred probation for aggravated assault causing serious injury, now faces new charges involving weapons, evasion, and assault. What begins as a routine revocation hearing quickly spirals into a legal reckoning, complete with sharp arguments, explosive testimony, and a judge who's clearly had enough. Stay tuned, because this courtroom doesn't hand out mercy lightly.
You guys can make argument with regard to counts 7 and 8. The state, you may go forward.
Judge, I would argue that count 7 should be found true by preponderance of the evidence because Mr. Price testified that at the S&S grocery, which is a 51% business, that he did see the defendant chasing another male with a handgun. He was descriptive enough to say it was heavy set, he had no shirt on, he was driving a dark blue Lincoln Navigator. That the police pulled up before he left that premises and followed him. We know from Officer Powell that he followed that same vehicle until it crashed out. Inside that vehicle, or the vehicle was obviously driven by the defendant in this case. Inside that vehicle was a silver or chrome pistol, just as he described. That was the aggravated assault, was exhibiting a deadly weapon in the course of chasing the victim in this particular case.
All right, thank you. Mr. Smith, the defense.
Your Honor, as to count 7, that has to be found untrue as to what evidence was presented. The law of Texas is that a person commits a UCW if they carry a handgun in a grocery store. It becomes a felony of unlawfully carrying a weapon in a licensed premise.
Are you talking about 7 or 8?
I'm talking about 7.
7's not the unlawful carrying a weapon on a premises. 7 is the aggravated assault with a deadly weapon.
Okay, well, I misunderstood you.
This is where things heat up. The prosecution lays out a clear narrative. Eyewitnesses, matching vehicle, matching gun, and a chase that ends in a crash, all pointing directly to the defendant. Meanwhile, the defense scrambles to poke holes, arguing inconsistencies and technicalities, a classic move when the evidence looks airtight. But here's the key. In a motion to revoke probation, the burden of proof is lower than in a full jury trial. The judge only needs to find it more likely than not that the violation occurred, not beyond a reasonable doubt. It's one of the system's most misunderstood legal twists. So, if you were the judge here, would this evidence convince you?
I'm talking about the count of the unlawful carrying a weapon.
That's count 8.
All right, that's count 8.
And I'll cut that short. I don't believe I have enough evidence on count 8 with regard to the premises and what the percentage of is an alcohol premises and things like that. I don't know that there's enough evidence on that. So I'll find count 8 not true. Let's talk about count 7.
Yes, Your Honor, on count 7, we would argue that as we showed in the testimony from Mr.
Price.
That the statements that he made to the police and the handwritten statement that he made at the time of the offense are so inconsistent with his testimony here today that his testimony is simply not believable. In addition to that, the testimony from Mr. Price that he saw somebody chasing somebody with a handgun, the best way to describe that is that he saw somebody with what he thought appeared to him is a handgun. That does not prove, as a matter of law, that was a handgun. And so that evidence before the court that this man was chasing somebody else with a legitimate handgun, that proof is totally insufficient as a matter of law, and we would ask the court to find that to be not true.
Anything else from the state with regard to argument on that?
Judge, there was a handgun that was found in the vehicle. The fact that he chased him from business to business, both in the car and out of the car, certainly I think there's enough evidence to find him guilty of the aggravated assault.
Or find it
Or
true?
find it true.
So obviously, I, just like a jury, can make reasonable conclusions and deductions based on the evidence, and the level of proof necessary in a motion to revoke is obviously substantially less than that in a jury trial with a jury. I think the evidence from Mr. Price, the evidence from Officer Powell, there was no real lapse in anyone having their eyes on that vehicle and Mr. Randall at the time, from the call in to the cops getting there to him leaving, and being the only person in the vehicle with the gun being found that matched the description of the gun, somewhat that Mr. Price saw and that Ms. Officer Powell found in the actual seat of the driver. I am going to find count 7 true. So that makes, there were pleas of true again to counts 1 through 6. I'm finding counts 7 and 9 true. So now, Mr. Bruce Smith, argument with regard to punishment. The underlying offense, just for the record also, that Mr. Randall is on a deferred probation for is aggravated assault causing serious bodily injury. That was a 10-year deferred probation. You may proceed.
Your Honor, we would argue that what my client pled true to in counts 1 through 6 are all.
At this point, the courtroom mood shifts. The defense pivots to sympathy, citing medical issues, mental health, and the side effects of medication. It's a last-ditch plea for leniency, aiming to reframe repeated probation violations as the result of personal struggle. But Judge West is no rookie. She listens carefully, yet she keeps pressing for accountability. In her courtroom, excuses don't erase patterns. And remember, this defendant was already on a 10-year deferred probation for a violent assault. That's not a small mistake. That's a second chance on life. The question now: how many chances does one person deserve before consequences kick in?
Administrative counts, we pled true to those, and they're all dated back in 2023. It's my understanding that he got all that problems straightened out, and that the probation department was fixing to put him on reporting like every other month rather than every month, which indicates to me that they thought that he had straightened out his act.
Where do you see that? Is that in the report?
No, that's not in the report. That's just my understanding.
Okay.
And the statement, as far as the pre-sentence investigation update, the statement indicates and verifies that my client has had, medical problems in the past. And they repeated that he was taking medication back at the time that he was having these problems back in 2023, and that the medication had an impact on him that caused him to have these problems.
I want to make that's what he said to them.
That's correct.
Okay.
Yeah. But I think the record as a whole in your file indicates that he did have problems, mental health problems in his past. In fact, was seen going to a local mental top and was on medication. In that, we would would say, we would submit that that was the problems back in 2023. And that since that time in 2023, it wasn't until we have these problems in 2024 that we have this motion to revoke. So we're asking the court to take into consideration the fact that for a long period of time he was having only administrative difficulties in his probation, and that and I think that's important for the court to take into consideration. Since the court made a finding of true as to counts 7 and 9, we're asking the court to, if it doesn't see fit to continue my client on probation, we're asking the court to, if in fact it does revoke his probation, that his sentence into the Texas Department of Criminal Justice be set at no more than 5 years.
Thank you. Mr. Philip Smith?
Judge, we filed our first motion on December 8th of 2023, after he had been an absconder for several months. This offense occurred.
Your Honor, I would object. There is no evidence of him being an absconder for this court.
It's in the PSI, and you had no objections to the PSI. He failed to report February 20, he pled true to failing to report February, May, June, October, and November of 2023.
Yeah, that's correct, Your Honor, but I mean, absconder means he just disappeared.
Well, he did disappear. They didn't see him.
He admitted that there were certain days that he did not report, and those were the dates that he did not.
You did not
report.
object to the pre-sentence report, which also, we have the, you're the probation officer, correct, Ms. Bryant? Yes, ma'am. Would you please come up? Good morning, ma'am. Well, good afternoon. Would you please raise your right hand? Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth? Thank you. And I'm going to do this a little informally. We're not going to get into a whole lot of questions. You stated in the updated pre-sentence report that after the defendant had not reported for more than 90 days that he was changed to an absconder status December 5th of 2023. Is that correct? Yes. So from February until then in December, February of 2023 to December of 2023, how many times did Mr. Randall report? And if it's helpful, you can set your stuff down on the podium or whatever up here with whatever you need.
You said from February of 2023?
To December.
Four.
Okay, and when was the last reporting?
Of 2023 was August 10th.
Okay. All right. So once you hit December and that 90-day mark is when you guys changed it to absconder, and that's when that motion was filed and administrative hearing was done, correct?
Yes, ma'am.
What about...
This testimony seals the deal. The probation officer confirms the defendant went off the radar for 90 days. Officially labeled an absconder, one of the biggest red flags in probation terms. Add in failed drug tests, skipped check-ins, and new offenses, and the pattern is crystal clear. The prosecution isn't just asking for punishment, they're asking for protection of the public. The state recommends 16 years behind bars, arguing that every program, warning, and treatment option has been exhausted. You can feel the tension here. Defense arguing for mercy, prosecution demanding justice. But what side will the judge fall on? Keep watching, because this decision's about to hit hard.
Any information that you have with regard to Mr. Randall participating in Spindletop services?
Me personally, I don't have any information. I wasn't an officer at the time.
Okay. Is there anything in the file that you can tell that shows?
Give me one second.
Yes, ma'am. And when did you become his officer?
March of this year.
March of this year. So you weren't his officer back then. You're just going by what is, okay. All right. That clears up the absconder. Go ahead.
Judge, one of the last times he did report before absconding was July 3rd, which they gathered UA and he tested positive for methamphetamine. So we know he's committing multiple felonies over the course of being on probation for a felony offense. He is not a suitable candidate for probation. As the PSI officer stated, they have no desire, they believe the defendant has no desire to comply with the conditions of probation, and he's exhausted all appropriate sanctions and available programs. So we would feel like the only thing left to do is to give him appropriate punishment. We would ask you to take the facts of the underlying crime into consideration. It is an aggravated assault. He has committed another aggravated assault with a firearm this time, and we feel like no less than 16 years in prison would be appropriate in this particular case. So that's what we're asking.
Thank you. Okay, so I just want to go through, Mr. Randall, one of the reasons why I asked the probation officer some specific information about whether or not you had reported during that year, which you did, and it's actually in here. You reported March and April, in July, and then again in August. And you were given information on those about the anger management class. You made a statement that you were taking medication that made you forget about your probation. But, okay, so, but you showed it. So it's not like you started taking medicine and you never showed up. You did show up some of those times. So I've never heard of anyone having any type of medication through Spindletop or otherwise that makes them forget about going 1 week but not forget the next week. You were given, you just quit going to probation. Tested positive for methamphetamine back in July of 2023. Had one more appointment after that, stopped going, and then you're running around chasing someone with a gun and evading on foot and in a car. The underlying offense, and when I look back at that pre-sentence report, the fact that you were given a probation on this case in the first place was a big deal because you have a ton of history out of Louisiana. And so you were given you've had a 15-year sentence in Louisiana. You've had 3 years, 18 months. We've got a couple of times where they couldn't figure it out because Louisiana's not always easy to figure out. You had a probation just in 2021 that was revoked on a driving while intoxicated, and we still gave you a probation after you did what you did to Miss Edwards. Threw her around, hit her in the face, threw her where she hit her head, had to have stitches. Sometimes I look back on these and I wonder why I gave probation in the first place. At this time, I am going to find again that you entered your pleas of true to counts 1 through 6 freely and voluntarily. Find those counts true. Also, find counts 7 and 9 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault, family violence. Sentence you to a term of 15 years in the institutional division of the Texas Department of Corrections. This is not an agreement. You do have some rights to appeal. I'm going to hand you the trial court certification. Mr. Smith, y'all need to get that signed, please, so I can get him a copy.
And there it is, 15 years in state prison. The judge lays it out with surgical precision. Repeated violations, violent history, absconding, and zero follow-through. Every second chance was squandered. What's powerful here is the contrast, how the law bends toward rehabilitation until it simply can't anymore. Judge Raquel West highlights a brutal truth of the system. Probation is a privilege, not a right, and if you abuse it, the mercy runs dry. This case is a sobering reminder of accountability and the cost of wasted opportunities. But what do you think? Should the judge have shown leniency given his mental health struggles, or was this outcome inevitable? Let us know in the comments. Hit like, share, and subscribe for more real courtroom breakdowns only on Courtroom Chronicles.